May it please the court, my name is Corrine Mull, and I have the honor of representing the Hendersons in this case, the mother and father of the children in whose interests we are proceeding in this case. The right to the custody and control of one's child is a fiercely guarded right in our society and in our law. It is a right that should only be infringed upon under the most compelling circumstances. And those are the words of this court back in 1986. Since that time, we have a new juvenile code. Here, appellants, in the case before us, appellants faced a juvenile court that not only seized their children without compelling circumstances, but also deprived appellants of the most basic fundamental rights. The juvenile court denied appellants their right to counsel, their right to notice, their right to be heard, and their right of confrontation. All of these protections are guaranteed by the U.S. and Georgia constitutions and are codified by the new juvenile code. As a result of these egregious violations, appellants were rendered completely unable to prepare or present a defense to the accusations against them. The deprivation of procedural due process, combined with the absence of oaths or any witness testimony whatsoever, resulted in a null and void order. This court has ruled extensively on the necessity for due process in juvenile proceedings, and the Georgia legislature, as I've said, has codified all of the rights addressed here. So there are three layers that can be looked at. Looking at the code, we have answers to all of the issues in this case.
Let me stop you here. What's the difference between a protective order and a dependency order?
It's a difference in terminology, but what a protective order is the order that is held, that is issued after a dependency hearing has occurred.
Did that occur in this case?
Yes, it did.
Okay. Now, where in the code does it say if you violate a protective order, that can be used against you to take your children away?
It does not say that anywhere.
Okay.
In fact, everywhere in the code, at every turn, the intent is manifest, and that is to provide due process to the parents and to the parties before the court. The judgment in question came at the end of a judicial review, and that is after protective orders have been entered into, looking at the protective order and seeing how people are complying with it.
But which one? But that's what I don't understand. That's what I'm trying to get at. Was it a protective order, or was it a consent dependency order? Or was it both? And if it's both, how does it be both? Where does it say you can do that?
It is actually both, Your Honor. It's a dependency finding. The protective order is a dependency finding that the children are dependent. In this case, back at its incept of the case, we had a consent finding of dependency, but that was way back when.
Sure.
In the case we're in before the court right now, the parties.
What I'm getting at is the state, in their brief, consistently refers to this as a protective order. And they put it in quotes. They set it apart. Protective order, protective order, protective order. I look in the code, and it tells me at 151129, the protective order, it says, after notice and opportunity for a hearing afforded to a person subject to a protective order may then be modified. Then I see the state says, nope, a court has the inherent authority to amend anything, anytime, without notice on anything. I don't see how you reconcile the two. I want somebody to help me.
Well, Your Honor, I think it's clear but muddy, but at any rate, it is clear that what is happening here is the juvenile code, the new juvenile code, and to some extent the old juvenile code, dwelled on procedural due process, on giving rights to the parent. The protective order is what is issued after the dependency to protect the kids in the home. So that if something were to happen to the kids, you can yank the parents back in. But nowhere does it say you can yank them back in and take them away from the parents without due process, without a lawyer, without witnesses, without...
You got to have an emergency hearing.
You got to have an emergency hearing. And in this case, that's not what they did. The judge in this case was specifically asked by the clerk, is this going to be a preliminary protective hearing? And he said no. He was very clear about that, and I think we should take him at his word. It is no, and had he intended in his mind for it to have been an emergency hearing, he would have had to have set the hearing for 72 hours later, which he did not do. Clearly, the court was relying on the inherent right to modify, and that is provided for.
You think the court was doing that then?
I think so. I think ultimately that's what the judge relied on.
Ultimately, but I'm saying on January 20th, 2016, you think the judge thought, I can modify anytime I want to modify? Don't have to give any notice?
I think he, with all due respect to the court, I think he was so unhappy with the situation before him that he wasn't...
Tell me a little bit about that. Tell me a little bit about the history and this kind of obvious animosity that built up between the judge and your clients. Can you give us a little bit of the backstory on that?
I think the state would give you a better backstory, but I'll try my hand at it. I came in on the case at the tail end. There were protective order was entered, and there is dispute by the family with whether they complied with orders. And throughout the history of this case, the judge felt, it would appear, that the family was not moving fast enough and not getting off of drugs fast enough. But at no point was there ever any finding that the children were at risk or in danger. At no time.
Which is required.
Absolutely.
To take away someone's children.
No finding whatsoever. What was egregious is that all the rights that are permitted to our clients all telescope into the right to counsel. If you don't have the right to counsel, you don't have the right to anything else. And in this case, the court had no problem with denying them the right to counsel.
Well, and even more fundamental than that is the right to familial relations.
That's correct, Your Honor. That's very correct. And in this case, Judge Self asked me what I think in this case, the court, as the court said, it's me against you. And
that's really, I think that's stunning that was said by a judge. Did anybody move to recuse this judge?
Not at that time, Your Honor. I think we were all stunned. And that was the last order. That was the final order.
I mean, I just find that shocking that a judge would say that in open court. Or anywhere, for that matter.
I'd just like to reserve 5 minutes.
May I make a recommendation?
Sure.
Why don't you reserve the balance of your time? I want to hear from the state.
Okay, I will do that. Thank you.
So what's going on here? Because I'm going to tell you, it doesn't look good. I do not envy you being here. Obviously, it's not your fault, but what's going on here? Help us understand what this judge was doing.
Well, this juvenile court did nothing wrong in transferring the children from the appellant's custody to the custody of the department. This case is not so much about what the juvenile court did, but the appellant's own actions. This case is about
what could an appellant do? What could an appellant do that would cause him or her, in this case both, to not get a right to a lawyer? To not get a, let me read to, because I'm reading 1511:19. A party has the right to be present. They got that. They did get the right to be present. To be heard. Nope. To present evidence material to proceedings. Doesn't look like it. To cross-examine witnesses. Doesn't appear from the record. To examine pertinent court files and records. Don't know. And to appeal the orders of the court.
Yeah,
What can somebody do to lose this? The people gave this to the litigants. What can they do to lose
And
it?
forget about all that for a second. That statute has to be read through the lens of the Constitution. We're talking about interfering with the right to familial relations, the government coming in and taking custody away from parents. And it looks to me like there was little to no due process. And not only that, but in making the consideration, because of that constitutional requirement, protecting a fundamental constitutional right, we require clear and convincing evidence before we take away someone's kids, based on evidence at the time of the hearing, if there even was one, whether it's termination or custody. So help me understand.
Well, I need
What
to
the-
point out that there was no deprivation of the right to counsel. They did have counsel at the time of the hearing. And in fact,
I mean, the hearing,
these were-
the previous hearing?
they had it at they had it at all stages of the hearing, and they had it at the juvenile review hearing.
Well, I thought counsel withdrew right before the
They
hearing.
withdrew,
And
but
they asked for a continuance, and the judge said no, which meant the purpose of the continuance was to get a lawyer, and the judge acknowledged the motion but said no. I'm not going to
no,
continue.
what happened was the appellants had gotten that notice. They had already taken steps to get another attorney, and they had already hired another attorney. That attorney could not be present at the time.
Right.
So they had were not deprived of their right to counsel.
Well,
And these were not-
wait a minute. Did they have a lawyer there that day?
They did have a lawyer who was allowed to withdraw, and then they had.
Okay, so that means at the time of the hearing, when all this stuff happened, they didn't have a lawyer that was there, right? You agree to that? Well, I mean, no.
Physically present.
Was there a lawyer at that hearing? The one withdrew. He's gone. Was he there?
He was not there, but
Okay.
this is the standard is these were not indigent counsel. Now, in dependency proceedings, you have the right to counsel, but you also have the right to waive counsel. And what the juvenile court found here was that appellants had waived counsel.
This is the
standard-
juvenile court that says it's me against you? This is the judge you're
Well, that was
defending?
taken out of context. The juvenile court obviously had no animosity. The animosity was one way because the juvenile court gave custody of the children back to appellants, even though they were open.
You know, I would have too. If I was juvenile court judge and then these people become felons, they're felons because of me, I'd get it back to them too and hope that's all that happened to me. But that's just me.
What did they do to waive their counsel?
Well, they had the standard, and this is listed and outlined in an interest of AMA 270 GA App 769, where you have a non-indigent counsel. The standard that you have to look at is whether they acted with reasonable diligence in retaining counsel.
Did
juvenile
the
court-
judge find on the record that they had waived their counsel, or did he
Yeah.
simply deny the
He
continuance?
found that he found facts on the record that showed that they waived counsel. He found that they had known about the hearing for over a month, and he asked them about their steps to secure counsel for that hearing. So
What did they say about the lawyer that they had talked to 4 days before the
they
hearing?
said they had hired an attorney in Fayetteville. That attorney had asked them to get a continuance, and that they had already hired him. That attorney was going to enter an entry of appearance. The juvenile court then said, okay, well, I will schedule another review hearing 1 week later.
But
1 week from the date that he takes the kids.
Yes,
Right.
which he did not. And I want to talk about the protections that parents get. All of the protections that appellants are mentioning, these are all protections that attach before a child is determined to be dependent. This case, the central problem with the appellant's appeal is these children had already been determined to be dependent.
Are you arguing then when DFACS comes in and says, well, here's our plan, and they haven't met it, then, and they contend, well, that's not true. We've met it, or they've misinterpreted it, that they don't have a right to confront the people that are saying that they haven't met their plan. They don't have a right to call witnesses. They don't have a right to require that the state prove those allegations, and they can test it by presenting their own testimony.
At that point, they have the right to appeal, because once a child is determined to be dependent, the juvenile court has broad discretion to act in the best interest of the children. That is what dependency proceedings are all about, and it states very
So
clearly.
why do we even have a hearing? Why doesn't DFACS just go to the judge, say, Judge, here's what we need you to do. We need you to sign the order, kind of like probation was doing in East Georgia, which the Supreme Court found to be unconstitutional, and go pick the kid up and, because you've already decided that they're deprived or dependent. But yeah, the procedures require a hearing, right?
The procedure is required back when the children are determined to be dependent.
So they didn't even need a hearing that
They
day.
don't need a hearing. They don't need notice. The juvenile court has the authority to act in the best interest of the children.
Based upon what, though? Because the juvenile court, in his infinite wisdom, can decide now this is in the best interest of the children, and I don't need to hear from the children or the parents or anybody else. As long as the government says it's okay, then by God, it's okay.
Yes, that's what the juvenile court has the authority to do, and your
That
remedy
is
at that
unbelievable.
point is to appeal. It doesn't make the order void.
So what happens during the appeal? You just don't have your kids. You have to wait 8 months for this court to rule
Yes, and it's the juvenile
with no
court.
due process.
Well, you do have due process. You have the right to appeal.
Let me tell you what went on here. This is my guess from being on the bench a long time, down in the bar fights that are Superior Court. I'm telling you this. So you're telling me that the DFACS can come to you, take your children, get you in front of the juvenile court judge, and says, "Listen, sign the consent order, and we'll let your children stay with you." And you say, "Whatever it takes, because I just want to go home with my babies. That's all I want to do." Kind of like the mama said here, "Please don't take the children." And they say, "Fine, just do it. You can DFACS, you stay at home with your children, keep rocking along, keep doing drugs. Just get off of them when you can." And then eventually, when you cross the DFACS, they go to the judge by themselves, and then they take your children, and that's constitutional in this country?
Yes, well, they had
Unbelievable.
counsel.
I live in the wrong
They
country.
had at the time they stipulated to the dependency, they were represented.
If that's
by counsel.
true, then the entire statutory regime in Georgia is unconstitutional.
Yeah, well,
I'm just telling you, because if that is honestly the state's position, then you're going to see something like the parole case. That's just unbelievable to me that that's the state's position.
Yeah, that is in fact what the juvenile code provides.
Wow,
Okay.
wow.
But I also want to mention, before you even get to the merits of this case is moot. They have their children back. They've already pled guilty to the criminal charges against them. This is not an issue of significant public concern, and it's not capable of repetition while evading review.
I got to tell you, I'm in the public and I'm concerned, because if you can take my children like this, then that's not going to work for me. That's just not going to work for me. You can't take my children like this. And I cannot believe that we're going to say that you have a lawyer, even if they're not present, you got a lawyer, and that's good enough for due process to lose your children. I mean, which is, as the United States Supreme Court, which is civilization teaches us that is the most important thing that we could possibly have.
Explain to me how the statement where the judge says it's me against you. Explain to me how that was taken out of context, because I'm curious how that was taken out of
The
context.
context was, it had been a year since the child had called police and gotten DFACS involved. This court had tried to work with the family, tried to keep them together, and said, "Hey, what we need you to do is go and address your drug addictions. The children have been harmed, and we're trying to keep the kids safe. What you need to do is go and do that. You need to stop using drugs, and you need to go and get treatment." By the time the judge had gotten to that point where he made that statement, they had done nothing. They had defied the court's
So that
orders.
justifies a judge in open court telling the people appearing before him he's supposed to be fair and impartial. He can look at them because they didn't comply with his wishes or the government's plan. He can look at them in open court and say, "It's me against you." I'm now putting myself in an advocacy position. The state thinks that's okay? The state thinks that's appropriate judicial behavior?
I do not agree with your characterization of what the juvenile court
Well,
said.
tell me what he did he or did he not say, "It's me against you"?
He said that, but it was out of context. This was the context of a juvenile court judge that is working hard to give these parents a chance.
That just sounds to me like an excuse for him being frustrated. What if right now during this argument I say, you know what, and you may feel this way, it's me against you. How's that going to make you feel when you go back downstairs? You're not going to feel like you're going to get a fair shake up here. Judges can't say things like that. I mean, don't you agree with that?
Yes, but you look at what the juvenile court did, and they acted appropriately. Once the appellants went to substance abuse treatment and stopped using drugs, he gave the children back. So whatever animosity, it did not affect his final ruling.
Does it bother you that he gave the children back on January of 2017? Is that right? January 20th?
No, he gave the children back in October, months before.
When was the order signed?
The order was actually signed later, but he.
Yeah, how much later? That's what I'm getting at. Like
Well,
January,
it was
right?
not immediately, but the children were given back October 19th, 2016, and then the order was actually written order January 9th.
Right, January 9th, 2017, non-proton to October the 19th. Doesn't that concern you? I mean, are you telling me that he had the children or didn't have the children then?
They did have the children October 19th, 2016. That's when the ruling went into effect. That's what's common in juvenile cases, is that the rulings will go into effect and the written orders, that's common.
Right, but if DFACS had changed their minds again, they could have gone back to the judge and said, hey, we just don't think this is going to work out again, so we know you gave the children back, take them back away because you never signed the order.
Well,
They
at
could do
that point, it would be a new dependency hearing, and then you'd have to go through the proceedings. They would need counsel, they would need hearings, they would need all the testimony.
Why doesn't the judge just rely upon the amorphous, I amend my earlier order at any time for any reason because I feel like I can?
Because the appellants would have gotten their children back at that time. And
I know, but he could amend the order.
No, you wouldn't have jurisdiction over the children at that point.
Why? There's no order.
Because there would be no dependency, and the appellants would have custody at
But
that point.
under the Civil Practice Act, the order doesn't count until you file it.
Well, if they
You
had
can't be
already,
held in contempt unless there's a written order.
I'm
Judge Miller
not sure
teaches
I'm
us
following,
that.
because if the court has given custody back to the appellants and said there's no more dependency here, the court can't act unless there's another finding of dependency, another dependency petition.
Okay. All right.
So I think that the crux of the matter here is there was a finding of dependency. Appellants do not challenge the fact that the children were dependent. Since the children were dependent, the juvenile court had the authority to do what it did in this case. That doesn't, even though Your Honors obviously don't agree with what the juvenile court did, that doesn't make their order void.
Do you agree that our juvenile code has to be viewed through the lens of the Constitution?
Yes.
Okay.
And the children also have constitutional rights. And the juvenile code also
Historically,
specifically
that's
states
not accurate. Historically, that's not
that
accurate. I'm
children
not
don't
sure.
have constitutional rights.
Children, as part of parental rights, are part and parcel of their parents.
Well, the juvenile code states that the children are a party to the proceedings and they have all the rights of the parents.
Who represented the children?
They had an attorney, but they did
Was
not
the-
file. They did not file any motions in this case.
Was that lawyer present that day that the court changed its mind and DFACS told him to take the kid away?
The attorney was present. It was listed on the transcript. Did not make any motions or filings.
Who
But they
appointed
are
the lawyer?
required to be represented at all stages of the
Who
proceedings.
appointed the lawyer for the children?
The juvenile court, in all probability.
All right.
All right.
Thank you.
Thank you.
Thank you.
Your Honor, I'd just like to address some of the issues brought up by the state in this case. Parents did not consent to a finding of dependency in October, November, December, or January of 2016. It was back in September that they had filed that they had consented to dependency back then, in much the same fashion as you outlined, where they were told they could keep their children, just sign here, and everything will be okay. And so they consented that children were dependent, and they went on their merry way. In this case, Your Honor, the court the code is very clear, and in 1511 19A, they talk about the rights of parties to proceedings, and general provisions are applicable to all proceedings. They don't have just a right to a lawyer at the dependency hearing. They have a right to a lawyer every time the court convenes and discusses anything having to do with their case.
Well, the state conceded that they said you waived it.
There's absolutely not a scintilla of evidence that we waived. My clients were in distress. They were saying, please don't take the children away. They never waived. They were never asked if they were waived.
What were the reasons? Well, okay, but I guess what the judge is doing is he's saying that by their actions they waived it. So what did he give as the reason that they waived it? Did he give a reason? Is
No,
counsel
he didn't.
correct?
He didn't even say they waived the hearing in the order. He just
Did he say anything verbally at the
It's
hearing? Like,
against you.
okay.
Well, that's at the last, that's at the null and void hearing a year later. And
Yes.
that's also when the judge explained that the reason he took the children away a year earlier was because he didn't trust them. And I have looked in the code, and trust isn't in the text. I keep looking for it, I don't see it. Whether you
Additionally-
trust somebody or not doesn't seem to be a valid legal basis to take someone's children.
And Your Honor is completely right.
But he trusted them enough to let them live with him.
Excuse me?
He trusted them enough to let the children live in this deprived, dependent state for 6 months.
That's correct.
What was the reason that was just going to be reflected in the record that the attorney withdrew, that did withdraw?
Because it's not going to be reflected in the record because she didn't testify.
So the
she
judge
didn't speak
wouldn't have acknowledged. In other words, she didn't provide an affidavit that said I'm not being paid. She just withdrew.
No, she withdrew saying in her affidavit, the claim was the clients are not doing what I'm telling them to do.
But that's
There's also in the briefs, there's also a reference that she couldn't ethically represent both people,
both parents.
both parents. That's in the brief.
And did the judge at the hearing give a reason for his refusal to continue? I mean, I know counsel for the state has argued that, well, there was another review a week later. But at the time that he went forward with the hearing without counsel for your clients, did he give a reason why he wouldn't continue the hearing?
No, just in his written order, he did say that he did not feel that he did not feel that they had acted properly in not appealing their decision right then and there.
Appealing
He
the
felt
decision?
they waived it.
I'm sorry.
I
Help me
said
out.
he justifies this by saying, by their actions, exactly like the state said, by their actions, they waived it.
They waived it generally, he said, but didn't give, they did X, Y, and Z, or didn't do X,
No.
Y, and Z.
No,
And that was in the order that he signed months later.
that's correct.
It wasn't said that day.
It wasn't said that day.
Was there a hearing held a week later?
No, there wasn't, because my clients chose their children over
No,
a null and void
you're talking
order
back in
and left.
September. I'm talking about when he took the children and
No, they left to Alabama.
They
That's
left
why
to
they felt
Alabama. They
that.
took their children
Let's
and
see.
left, actually, to New Orleans, and they were good parents. And even taking parents away from their children, or let's look at it from the children's perspective. What kind of trauma is this to be torn away on one moment's notice from your parents, who are not abusive parents to them, who are not endangering them in any way? As a matter of fact, the children's attorney stated to the court that he had no safety concerns with the children being returned to the home.
Have you ever had an opportunity to go talk to a juvenile court judge by yourself with the school's teachers and tell them that how good these children are doing and how wonderful they are, and get up some affidavits and stuff from maybe some pastors and some teachers, et cetera, and just go tell the judge and don't tell the defects about it, don't tell the state, and the judge do that for you?
Not at all, Your Honor.
I doubt
Never.
that happens. It never seems to work in favor of the people. It goes in favor of the government, is what I see.
That's true. It's, I'm here to help. I'm from the government. That's what this boils down to is a case where the government took over and denied them the rights that they are guaranteed under the Constitution. More importantly, Georgia, the statutes provide for it. I see my time is up. I thank you, Your Honor, for your attention and your question. I have 1 minute. I just would ask the court to find that in fact, the court did in fact enter a null and void order, and as in all null and void orders, they don't have to be obeyed. My clients did nothing wrong in taking their children, yet they're saddled with a felony conviction, each one of them.
Okay.
And the case is not moot, Your Honor. The case was not. You have to have final orders in order to have mootness. There were no final orders in this case, and more importantly, the juvenile case resolved itself before the criminal case. So how could they be stopped from?
We'll deal with the motion to dismiss in the order.
Oh,
We'll deal
Thank
with
you.
that.
I want to thank both counsel for the excellent presentation today and your excellent briefs. I do, for all of the interns out here, I would like to highlight State's counsel as a great example of having very active questioning, and I want to highlight and commend her for her professionalism and under withering. That's a great example for all of you. She always remained calm and professional under very intense questioning, and I just want to commend you for that and your professionalism and representing the state well, and I also commend you for representing your clients.
I was going to say that Judge Dillard stole my thunder, but I wanted to say that to you as well. It's not easy to take questions like that, but you were calm, professional, did a great job, and I mean that sincerely. You did a great job.
So thank you both very much. Safe travels back to your office. You just have to go down a couple of floors, but thank you all very much. We're in recess.